Hey, Professor Tracy back with another negotiable instruments lecture. This one on accommodation parties or guarantors, sometimes also referred to as a suretyship obligation. This falls under the heading of liability on the instrument. So in the previous lesson, we looked at various parties such as the issuers or endorsers or acceptors that were signing on the instrument and how their liability worked. And in this lesson, we're looking at someone who signs an instrument in order to guarantee payment of that instrument. So let's hop right to it. So let's jump into first just an overview or introduction and thinking about how a loan generally works. And we don't often think of it this way, but when we are talking about a lender, they are selling money. They are selling money and they are exchanging that money in exchange for a pinky promise to pay back, right? A promise to pay back. And so there's a contract at the bottom, at root, where even when we're talking about a loan for money, it is the lender saying, I will give you this money. I will deliver to you these funds, and you will, in exchange, promise to pay me back. Principal plus interest at whatever the rate may be. And so that's how we need to think about these transactions, that there's a loan is a sale of money in exchange for a promise to pay. And so when we're thinking about it, we have a borrower and we have a lender, and the borrower is promising to pay back the lender, to pay them the interest, the principal, and in return, the bank, the lender, is promising to deliver the funds. And that promise to pay is what we want to focus on for a second, because this is the whole reason that guarantees even come up. So it's the value of that promise of the borrower in the example we were looking at, Barb's promise, that's going to determine what kind of deal she's going to get, right? So the value of the borrower's promise dictates the terms of the loan that they get. Meaning if it's worth more, if their promise is worth more, they're going to get a better deal. So if we're looking at Bob here and we say, oh, he's a high value borrower, then he's going to get better terms. And so the more valuable he is, then meaning the less risky. What makes him valuable is he's less risky, right? He's more likely to repay the money back on time, and in full. And on the opposite end of the spectrum, if we look at Bo, and Bo is a low value borrower, his promise to pay is not worth much, then he's going to get worse terms, right? Because he's more risky. If he's more risky, that means he's less likely to repay the money on time or in full or at all. And therefore, he's going to get worse terms. So one thing that a borrower can do, either to qualify for a loan in the first place and incentivizing a lender to work with them at all, or to get better terms from the lender, then the borrower needs to increase the value of their promise back to the lender. So they need to decrease the risk, right? They need to decrease the risk and increase the value, right? Decrease the risk, increase the value. And there's two ways that typically borrowers will do this. One is to put up collateral, right? If you are financing something, if you're financing the purchase of a car, it may be that you are giving a security interest in the car. If it's some other kind of purchase, you may be putting up collateral, right? Obviously with a house, you're giving a mortgage. You're putting up collateral for that loan. And that's one way to increase the value. Is there something set aside that the lender has an interest in that they can leverage if the borrower doesn't pay? But the other way to increase the value and decrease the risk is for the borrower to get a third party to come in and guarantee repayment, to be a guarantor. Often we refer to this as somebody co-signing a loan. And that's really common, for instance, if perhaps when you were younger and you wanted to purchase a car, you may have had to have your parents co-sign the loan to purchase the car if it wasn't something you could purchase outright. And for many of us, that's not something we could do. It certainly wasn't something I could do or my parents could do. So when we're thinking about this second option, having a third party guarantee repayment, is what we're going to focus on in this lesson. And so if we have the borrower here, Barb, and she's approaching the lender, the bank, and we have this same transaction that we were just looking at. She's promising to pay money, they're promising to deliver the money, and as we said, typically that exchange is they're delivering money, and the promise to pay from the borrower is to promise to pay that money back plus interest over some period of time. But what Barb can do here in order to increase the value of her promise to pay to the lender, to the bank here, is to bring in somebody as a guarantor. And so if they the bank looks at her and goes, "You're too risky. Your promise isn't worth enough to us. If we lend to you, it will be on crappy, horrible terms." So if that's what they think, then she can get a guarantor, right? And Bob comes to help out. And Bob is going to then promise to say, "I guarantee the repayment of this loan. I'm going to guarantee it." That means that suddenly the value of this promise goes up because there's somebody, ideally somebody with better credit or who's less of a risk, coming in to guarantee payment of that loan on behalf of Barb, the borrower. And so the bank says, "That's a lot better. We'll give you better terms now." So that's the situation we have, right? That's the effect of the guarantor coming in here. Now, if there is a note involved, and after all, we're in negotiable instruments, so we're not just talking about a loan transaction as a contract, we need to have a negotiable instrument in the picture. So if there's a note involved here, and Barb executes that note, and then Bob executes that note, he's co-signing that note, then that note is then delivered, right? It's issued to the lender here. Then when that occurs, when Bob is co-signing that, he's going to be liable on the note. In the previous lesson, we said when somebody signs the instrument, they are almost always liable on it. And in this case, Bob would be liable on that instrument, which he just signed, the note, as what's called an accommodation party. An accommodation party. So that label comes up when it's the person guaranteeing repayment and it's noted on the instrument itself, or we'll see it can be in an attached guarantee agreement. But it's relative to the note that we use this phrase accommodation party. So here, we know now he co-signed the note. That makes him the accommodation party. And what Article 3 calls Barb is the accommodated party. She's the one who has been accommodated by Bob's guarantee. And so here, when a signer is an accommodation party, in other words, when is that and what does that look like? So if we look at Section 3419A, it gives us a definition. And it's fairly lengthy, but it's not actually that complicated. Let's read it. It says, if an instrument is issued for value given for the benefit of a party to the instrument, and it says to the accommodated party, and another party to the instrument, the accommodation party, signs the instrument for the purpose of incurring liability on that instrument without being direct beneficiary of the value given for the instrument. The instrument is signed by the accommodation party for accommodation. So the issue then is, what is the party, right? We just labeled our parties in the previous diagram, right? We previously labeled the accommodated party as being Barb, and the note is issued for Barb's benefit, and she's the one getting the value that's being given for the note, right? The money for this loan transaction is going to her. That's what it means when it says the value. Well, the value is being given to Barb, right? So the note is then she's the one deriving benefit from the note. When Bob signs it, all he's doing is incurring liability. He's not a direct beneficiary of value being given by the bank, right? The bank's not giving him the money. So we can look at it and say, well, that's not, in this case, that he is not the one, because he's not the one directly benefiting. And keep in mind, it's okay if there's some indirect benefit that he's getting. The question is he getting any of the loan proceeds? And the answer is no, he's not. He's just incurring liability without getting any of that money. Therefore, he's an accommodation party. That's the way that Article 3 defines whether or not he's an accommodation party or something other than that. So if he's an accommodation party, then an accommodation party may sign in any capacity. Well, what does that mean? Well, we've looked at a number of capacities over the scope of the different negotiable instrument lessons, right? So one would be you're signing as in this case, which is the likely thing, that he's signing in the capacity of a maker of the note. It could be you're signing as a drawer of the check. It could be you're signing as an acceptor. We talked about what an acceptor is in the previous lesson, being that sometimes a bank, the drawee bank, will take the check and accept it, sign it as an acceptor. If the party is signing in that capacity, then that's what they would be, right? If they could be, the accommodation party could be an endorser, signing as an endorser. And the thing to know is whatever capacity the party is signing, the accommodation party is signing the instrument in, then that's the capacity in which they are liable. They are liable like any other maker would be if they're signing as a maker. If they're signing as a drawer, they would be liable like any other drawer. If they're signing as an acceptor, they would be liable like any other acceptor. If they're signing as an endorser, like any other endorser. And we looked at all of those roles in the previous lesson. So don't have all of what we talked about in the previous lesson go out of your mind, right? It's obviously relevant here. And so one of the things we got to be thinking about when we're thinking about, well, what capacity is the person signing the instrument? Are they in fact signing as a accommodation party or not? We've got to look, and the Article 3 says, well, it depends on how clear it is. How clear is it in the way that the instrument was executed, the way that it was signed? How clear is it that they are in fact an accommodation party? If it's clear versus unclear. And so let's look at if it's clear first, if it's clear. So here would be an example of where it's clear, right? We have the terms of the note here, and here they're clearly identified, right? Bob is clearly identified as the guarantor. It's labeled, and both parties are labeled. Their capacity in which they're signing is label, their title, their role. So it's clear, right, that he is an accommodation party, but it isn't always, right? So it might be unclear. So say here where there are no labels, this is the same other than the fact that there are 0 labels, right? Well, they could be equally, is this an accommodation party? Or is this actually like they're both makers on this note and we treat them both at that level, right? That they're both the makers on the note and not that he's an accommodation party. So those are important things to get straight. Well, what happens if it's unclear? How does Article 3 sort that out? What it says is it becomes a question of fact. It becomes a question of fact. And we're going to look at things, right? The court's going to look and say, well, who received the money? Because if Bob's not getting any of the money, if this party that signed isn't getting in the money, then that leans in favor of saying maybe they are an accommodation party. Maybe they are just a guarantor because they're not getting the benefit of this money. And when factually looking at all the circumstances, who is it that led these negotiations? If Bob was just kind of involved on the fringes here, then that indicates that this is more about Barb getting the money than it is about Bob, right? That he's just kind of playing this role of a guarantor or accommodation party. And one thing Article 3 drives home, it says if this signing, the signature that we see is an anomalous endorsement, then we presume that they're signing as an accommodation party. Keep in mind that an anomalous endorsement means that somebody signed as if making an endorsement, but that endorsement is not necessary for anything. It wasn't necessary in order to negotiate the note. That's why we call it anomalous. That it's not the kind of thing that someone would sign in order to go to one of our purposes when we talk about, well, why is it that a party would endorse? Well, if it's not one of those, right? If it's not because they're clearly intending to negotiate the instrument, or that they're intending to guarantee payment as an endorser, not as an accommodation party, that if they're doing that kind of thing, that's fine. But if they're not, then we presume that signature, that's quote unquote anomalous endorsement is really meaning that the person signs as an accommodation party. So if it's unclear, these are the kinds of things we look at. Obviously, there are all kinds of things we could look at when we say it's a question of fact. We're going to look at all the surrounding facts and circumstances. So the other thing that comes up here when you're thinking about what capacity is this person signing and are they on the instrument, one thing is to distinguish between somebody guaranteeing collection of the instrument versus payment of the obligation that's manifested by the note. The typical thing that when we think of somebody making a guarantee or being an accommodation party, the typical thing we think of is that they are guaranteeing payment of that obligation, right? That they will pay if the other party does not pay, that they're saying, I will pay for this instrument, that pay for the actual loan obligation. Guaranteeing collection is different because what you're looking for to know, like, well, are they limiting themselves to only collection? Is that the only liability they're agreeing to? You're going to want to look for something like collection guaranteed, which is kind of like somebody putting no recourse, but different. Obviously, it has a very different function, but it's the same kind of words of limitation, right? Where you're trying to limit what it is, what your liability is, what your exposure is. Here you're saying, I'm guaranteeing this, but what I'm guaranteeing is collection, not payment of the obligation. And Article 3 says that's fine. And if you do that as an accommodation party, then here's what it means. It means that that accommodation party is only liable if one, and these are ors, we'll see these are ors. One possibility is they're liable if there's been a judgment executed against the accommodated party, Barb in our example, and it's returned unsatisfied, meaning they're not able to satisfy that judgment, and that's what you're guaranteeing, right? Is collection of the judgment, and you're saying, or another possibility that you would be liable when you're guaranteeing only collection and not payment of the obligation is if the accommodated party is insolvent, then that means there isn't going to be collection of any judgment or anything like that. So that would mean that your liability is triggered. The same thing would be true if they can't be served with process. If you can't find them to serve them with process, then you're not going to collect on any judgment. And so that would be another reason why you would be liable, right? These are all ors, or, right? The fourth and final reason would be this catch-all that Article 3 gives, which it says if it's otherwise apparent that you're not going to get payment of the judgment from the accommodated party, then you're on the hook. So if there's some other reason that you're not going to get payment from them, then that's why you would still be on the hook. But the key thing to understand there is you're limiting your liability as the accommodation party to collection of the judgment only. Right? So let's talk about one of the rights that an accommodation party has, which is called the right of reimbursement. So if the accommodation party ends up having to pay, so let's say, there's no words of limitation here. He's guaranteeing payment of the obligation. If he ends up having to pay, then he has a right of reimbursement from Barb. Now, keep in mind, if Barb's not able to pay, then it may not be worth much to have a right of reimbursement, because if she is struggling financially to the point that she can't pay back this loan, then it's super unlikely she's going to be able to reimburse Bob anyhow. But there is the right that's there. And so the thing to know about this right of reimbursement here is to keep in mind that's saying, yes, it's Bob being able to get a right of reimbursement against the accommodated party, but the inverse is not true, right? The inverse is not true. If Barb ends up paying the loan, she doesn't have any right of reimbursement to say, well, I can go after the guarantor and have Bob pay. No, it's a one-way thing, right? It's a guarantee and Bob, as the accommodation party, has a right of reimbursement, but not the reverse, So that's important to keep in mind. Simple, but then on to defenses and discharge of the accommodation party. So defenses first. In one respect, this is pretty straightforward, which is to say, if Barb has a defense against the lender, the bank, then Bob may assert that defense against the lender as well. Whatever defense Barb would have against the lender, Bob can also assert that as the accommodation party. So you can think of examples. Let's say the bank never delivered the funds to Barb, so they breached. Well, that would be an example of a defense that Barb could raise, that Bob could also raise. But there are some exceptions. Not every defense that Barb could raise, Bob could also. And even before we list those, just keep in mind what we are not saying. Don't forget the holder in due course rules, right? Whatever defense it is would still have to be, if the party that is seeking to collect from Bob, the accommodation party, is a holder in due course, then all those rules apply as well, right? So even if there would be some defense that Barb has, if it's not a defense that could be brought against a holder in due course, it still could not be used, right? But at bottom, it's still the case that if there's a defense that Barb has, Bob can assert that, subject to these exceptions from 3305D, which says not if it's a discharge and insolvency proceeding. So if the obligation was discharged in insolvency proceedings, then Bob can't use that as a defense, even though Barb could. And if she had a defense, remember, minority or infancy is a real defense, right? A real defense. which could be used even against a holder in due course, Barb could use that defense, but Bob could not use her minority or infancy in order to have a defense against the lender. And the same thing would be true with a lack of legal capacity. For instance, we talked about a lack of legal capacity with regard to a corporation that may not have existed at the time the transaction was entered into. If that's the case, same thing. Bob would not be able to assert that if it's something that because of why? Well, why any of these? The rationale being that these are all personal defenses to the accommodated party, and so they cannot be raised by the accommodation party. So in these cases, remember what these are. These exceptions are exceptions to our rule that the accommodation party, here Bob, can assert the defenses of the accommodated party, Barb. Ordinarily, the answer to that is yes, but not if it's one of these three, because they're personal to Barb. But also, so in addition to defenses, we have discharge, which is saying you're discharged, you're discharged from this transaction, you are not liable. So there are two possibilities, right? One possibility is given to us by section 3605A. 3605A says if the lender releases the borrower, so our bank releases borrower without retaining rights against the accommodation party. So they have to specifically retain rights against the accommodation party if they're releasing the borrower. So if they release her without retaining rights as to Bob, then he too is released or discharged from this from his guaranteeing responsibility. So possibility 2 is from section 3605 instead of A, it's from subsection B, which says this, that the accommodation party, again, Bob, may be discharged if the lender, the bank, does something to increase the risk to the accommodation party. If they do something, if the lender here does something that's going to increase the risk to Bob, then he is discharged from this transaction, from his liability on the note. So what is it? What are the kinds of things that may increase risk for the accommodation party? The Article 3 gives us some examples. It says one would be giving extra time. If the lender gives extra time to the borrower, like extending the time that of when payment is going to be due. But here's one of the key things with each of these, but particularly this one. Not every extension of time is going to increase the risk for the accommodation party, right? In order for them to be discharged, they've got to show that this is prejudicial to them, that it in fact increase the risk to them in some way. Because keep in mind, just giving extra time in and of itself, you can't say, well, that means I'm having to guarantee for a longer time. Sure, but you've got to show why that extra time actually made it more risky to you than other than just saying, well, it was an extra 3 weeks or an extra, month, 6 months, a year, whatever. You've got to show that it in some way made it more likely that the borrower wasn't going to pay. And that may be because they're circling the financial drain, and you give them more time, they're going to be further down that drain and in worse financial shape. So it's more likely you're going to have to pay some or all of that outstanding obligation. That kind of thing is what needs to be shown, not just there was an extension of time given, therefore the accommodation party's discharged. That's too simplistic of a way of looking at it. You've got to think beyond that. Then you've got to say the other thing is if the terms of the debt are changed by agreement, the borrower, Barb, and the lender, bank, get together and they agree to modify the terms of that debt. If they modify those terms in a way that increases the risk for the accommodation party, then again, the accommodation party is discharged under Article 3. So that's again key. Again, you gotta look and say, does it actually increase the risk for that party? The same thing here, which is not the one that I intended to have on there. I apologize. When we're talking about this third one, well, the third one, if I remember correctly here, is impairment of the collateral. And here, so I will go in and fix that. That'll do little good for you, though, in terms of me going in and switching my slides. But in terms of this third one, it's supposed to be impairment of the collateral, meaning that if there is collateral involved and the lender, say, loses that collateral or damages that collateral in some way, then that, keep in mind, would increase the risk, right? Because that decreases the value of what the collateral would be worth, and that thus increases the risk for the accommodation party. And so the same thing you would want to say is the way that they've treated this collateral, or if they've given it up altogether, then any of those things impairing the collateral in that way would increase the risk for the accommodation party. And so keep in mind, here's the other thing that's so important to understand, is that this accommodation party, this party here, Bob, is only ever going to be able to get these protections of being able to raise the defenses of the accommodated party, and these protections of being discharged if there is an increase in risk to him, is only if the person entitled to enforce the instrument has notice that Bob is acting as a guarantor. And the most obvious way is if it's clearly denoted on the note itself that that's his capacity. If it's clear from the beginning, then they have notice. But unless the party that's seeking enforcement knows that that's the capacity in which he has signed the note, then he cannot avail himself of these defenses or of these grounds for being discharged from the transaction. So what about waivers? Waivers, if we're looking at Bob here and Bob's saying, I waive all the protections given to guarantors like me. Not that I know what those protections are. So this just circles back to what we just said, right? With these discharge, right? And remember, this is impairment of collateral. But so the grounds for discharge, they can be waived, right? They can be waived. The lender could require that the accommodation party, the guarantor here, that they waive these grounds for discharge. They could also say you've got to waive being able to raise the defenses of the borrower, these defenses, right? So those two things, those are what could be waived. And here's the kicker, is that waivers like this are super common. And if they're common, that means, guess what? When a guarantor is coming in and making a promise, it is often the case that they are saying, I will pay the obligation, period. Because they can't raise, if they've waived it, they can't raise any of these defenses that the borrower could have raised, and they can't argue any of these grounds for discharge that come up under Article 3. So then they have to pay, period. And so as Bob notes, wow, this guarantee stuff is pretty serious business. It is, right? You want to think twice, particularly if you're signing a guarantee that is having you waive all those different protections. And then one last thing to think about is the scope of any guarantee that's being made. One thing that is common, I referenced this near the beginning, which is that sometimes instead of just having the party sign the instrument itself, they will have the guarantor enter into a guarantee agreement that lays out all the waivers and all the rights and obligations of the accommodation party, the guarantor of that transaction. And if that's the case, if the guarantor signs an agreement like this, then it controls. You want to look to that agreement to say, what is it that says about the scope of what the guarantor guaranteed? Because that's going to control. So that's important. And it is sometimes, it might be a very open-ended guarantee that says this loan and any other further loan or something crazy like that, which means the person guaranteed not only the immediate loan, but any future loan that may be forthcoming from the lender. So there are things like that that may increase the liability of the guarantor in a significant way that wouldn't otherwise be true. So if there is an agreement, you want to think about, what does that agreement say? You at least want to look there first. It may not cover everything, and if it doesn't, then you fall back on what you need to of Article 3 or of contract law. So that's it. We're onward from here, being done with liability on the instrument. We're going to get to properly payable and wrongful dishonor. So with regard to checks, and I know everybody is psyched about that. So I will be in touch shortly with more. I pray that you're all doing well. If you found it helpful, please do like and subscribe. And thank you so much. I'll be in touch. Bye.